Ética para el desarrollo. Sergio Amenábar, Villaseca Abogados, Chile. Marco Aleman, OMPI, Suiza. Moderadora, Monserrat Alfaro.
So, good morning, good afternoon. Welcome to Ethics for Development. We thank you for being here, for showing your interest in this panel that will deal with a subject that is extremely important in our professional development. We thank CP on behalf of the Ethics Committee for providing us this opportunity to deal with the subject. We are very privileged. We are part of this association that has always paid importance and attention to ethics, being ethics one of its essential pillars. Today, I will make a very brief introduction on some overall ideas about ethics and ethics for development. And then I will introduce the panel members that will share the screen with us. And then we will proceed with questions and answers sessions. So to begin with, I would like to remind you that ethics as a discipline covers moral, virtue, duty, guiding our behavior, being the purpose to be fair. When we act, there are repercussions on the society, and we will see whether subjects respond to this. When acting, when choosing how to act, this has repercussions across society. On the other hand, the development of different groups of individuals throughout history is full of technological and scientific breakthroughs and developments that accelerated points. This is a clear example. Today we are living something with a pandemic. There has been like a race to discover new cures for this disease, but also a race to achieve new knowledge so that we can bring solutions to problems that come up. And I'm thinking of how to provide ventilators at low cost, among other things. So in summary, science and technology are the engines for development. At the same time, they are tools that provide extraordinary power to those who manage them. So the more we foster development by increasing the level of knowledge of certain groups, more responsibility is created, and we need to expand the ethic scope around it. So the ethics for development is a new concept stemming from the 60s after industrialization, and it's the result of economic and ethic thinking around development within countries and at an international level. And its main objective is to reach a fair society. So ethics for development is an applied kind of ethics that orients human behavior in the case of people who are involved in development. By talking about development, new concepts arise like education, culture, accessing technological resources, accessing information, breakthroughs, discoveries, research, natural resources, among others. All these concepts are somehow related with intellectual property, no doubt. So the right management and protection of rights stemming from creation and innovation are objects from an ethical point of view. So in the framework of an ethical discussion and its direct relation to intellectual property as a factor for development, I am honored to introduce our first speaker today, Dr. Sergio Amenábar Villaseca, who's a lawyer at the Pontificia Universidad Católica in Chile, partner and senior consultant for Villaseca Abogados in Santiago, Chile, former president of the Chilean Association for Intellectual Property, and he was also chair of the ethics committee of ACP. He was member of the faculty at the Pontificia Universidad Católica and the Gabriela Mistral University, and he has his diploma from a university in Chile. He is author of different articles and has presented at different international fora. Well, thank you very much, Monserrat. I would like to thank you and thank the ACP authorities for giving this very important space for us to talk about ethics during this virtual conference. Let me greet you and Marco and the other members of this group, and special greetings to members from Ecuador who, due to the pandemic, should be hosting this event but couldn't do so. That is why we have this virtual event. As you know, it was planned for Quito, that beautiful city, which is World Heritage. For this reason, I want to pay homage and I want to remember the former president of ACP, Santiago Bustamante, who was the organizer of the meeting in Quito when we held the first seminars of ACP. It was through him that we made such progress, so I want to pay homage to his memory. So, as an introduction, I would like to say that ethics for development, as Monserrat mentioned, is a kind of applied ethics, which deals with principles and values related to comprehensive advance of man and human communities. We place emphasis on actions and behaviors across countries as well. As one of its best representatives, Professor David Lett, said, there's little ethics for development can do without public action. In particular, when we talk about public actions of international organizations that play a very relevant role. Ethics for development stem in the second half of the former century, and it came alongside Father Levray, who was a theologian, economist, a social researcher, a missionary from France, who also contributed to Christian thought. He was one of the advisors of Pope Paul VI, writing Progress of the Nations, and he was also part of the Second Vatican Council, and in particular Gaudium Express. The development ethics appears as a reaction to development, just in terms of economic figures. This was the behavior that was popular at the level of international organizations after the war, and after making a tremendous effort for reconstructing the countries that had been devastated during the Second World War. It was then that we started measuring development as GDP, as per capita income, as income per capita, and so on. And it was at that time that we got a reaction from the fathers of the ethics for development, who pointed out that it was very important in the economic development, but as something that needs to be kept in good order, as Aristotle said, economic development matter is always organized depending on the individual needs and collective needs of men.
Therefore, the way development has to be measured is based on humans. Matter is important, material things are important, but only as a means to achieve happiness of human beings and to enhance their multiple capacities. Now, the main value of ethics for development, as might seem logical based on what has been stated, is human dignity. In other words, the respect that human beings deserve for the mere fact that they are such, that they are rational beings, they are independent beings, and the summit of creation. Human dignity presupposes or culminates or is the culmination of other values that have to do with applied ethics, to which we were referring, namely liberty, justice, independence, and participation. Now, before going specifically into ethics for development, I will delve into 3 ethical dilemmas of current times from which the conservation of human beings depends on, or at least the essence of humans such as we know it. These are the problem of the conservation of the environment, biotechnology and genetics, and artificial intelligence. The first if we were not to be able to preserve the environment, if we were not able to have an ethical manage of technology in order to improve the situation, the environment has undoubtedly worsened. This can lead us to go back to barbarous situation or to total self-destruction when facing vital limited resources, as is the case of water, as is the case of food, as is the case of the land itself, the soil itself. Imagine cities like New York or coastal cities are threatened at present. They are threatened by environmental problems. We have the problem of biotechnology and particularly the problem of genetics, which can lead to the fact that the human species might degenerate into something different from what we know it, and to a kind of cyborg or transhumans, and not to speak of artificial intelligence, which can lead, as Hawkins already said, to subordinate human beings. And this leads us to reflect on the fact of what might result from the combination of things that are not ethical when using biotechnology and artificial intelligence. Some people out there might have already seen human beings with antennae and maybe even with the tail of an animal to maintain the balance. And these are some of the problems. Now, these are some of the topics which could give rise to having a panel to discuss these things. And what I would like to say is just to state these in order to quantify and qualify the relevance of ethics in general of the current times with respect to technological development. Now, going back to ethics for development, I would like to highlight why we have related it to intellectual property. Intellectual property protects the creation of talent or ingenuity. In other words, knowledge. The new knowledge, particularly, and the industry, in technology, in art, and of course in science. And this is the knowledge, or rather the key for development. That is why we say we are in the society of knowledge. But right away, two alarms are set off. The alarm of distribution of wealth in general, in humanity. 80% of the wealth in the world is concentrated in 10% of the inhabitants. And what is more scandalous yet is that 50% of the wealth in the world is in hands of 1% of humanity. On the other hand, we have to consider technological wealth, which is the only way that is relatively certain. This is 85% in the hands of 4 countries and the European Union. In other words, of 5 political entities, 5 from 190 that make up the World Trade Organization. And this leads to a tremendous inequality, an inequality that is translated in the loss of political stability. And the loss of political stability is translated in revolutions, in social unrest, and many more things. And these are things we are witnessing throughout the world. And this added to the tremendous drama of vulnerability of human beings who could overcome poverty and now become part of the middle class. But as a result of this pandemic and the effects of the pandemic, these people are going back into poverty. This leads to immense frustrations. Now, obviously, intellectual property based on development is an adequate means to provide incentives for the progress of technology, culture, information, and knowledge. Intellectual property is an instrument to provide options to the capacities to improve human beings. And the product of knowledge is a universal asset, a universal good. This should be reachable by all human beings. This should be, the different nations should be able to reach this knowledge, and it should also be used by all human creatures. And that is a purpose of intellectual property. The purpose of intellectual property, in our opinion at least, is to enrich knowledge, but not to enrich just a few people, but to enrich the knowledge, to create more knowledge for the well-being of humanity. Those who do not understand that this is a purpose, the goal of intellectual property, is confusing the goal with the means. And the means, and this is what to some extent allows to generate wealth from intellectual property. I don't want to describe it just as property because this might lead to discussions. This is the moral acknowledgement and retribution to authors and inventors. Those who confuse things, putting acknowledgement in terms of assets before in the wealth of increase in knowledge, which is based on the technological wealth and culture. Those who confuse these things are just confusing the objectives of intellectual property. The means should be oriented at the end and not vice versa. And I want to say that we, and partly because of our profession, we tend to make this kind of confusion. That is why we have to be very careful, because we have to be loyal to our customers, but at the same time, we have to be loyal to humankind. We have to be loyal to our nations. We have to be loyal to the other people. And ultimately, loyal to the legal interest protected by intellectual property. Because when the means get mixed up and become an end, it often happens that the institutions are jeopardized. And if intellectual property stops having the end for which it was conceived, then intellectual property as such might disappear. It might be viewed as something that is negative with respect to the development of humankind, something that ethically is not right and something that should disappear or that essentially should be modified. Now, in the context of this panel, this leads us to analyze very global terms, namely the substantial international system of intellectual property, to ask ourselves whether this is adjusted with ethics for development. It is quite true that there are arguments in favor of accepting this system with the applied ethics.
It's been said that it has values such as balance, because it balances obligations in the short term and the increase of the intellectual property rights standards, especially for developing countries, with benefits in the long term, as it was estimated, because we are talking about end of the 80s up until 1995. It was estimated that the growth of intellectual property would attract important investment into the developing countries. And therefore, technological transfer was going to be possible. This was part of the ends of the TRIPS, to the annex of the TRIPS treaty, to prevent abuses. We said that independence was a value per se in ethics for development. And as one independence factor, we have the possibility of each country to incorporate the TRIPS standards into their national legislation. As one example of contribution to development, we have the TRIPS principles saying that with a safeguard of intellectual property rights, that can never be against health or education or food for the peoples in general. These are basic needs. And later on, after the Uruguay round, we have the ministerial declaration of Doha on public health, which breached the gap that was produced between the vested interests of holders of knowledge in the field of health and the users who practically had no access to that right. In addition, it is pointed out as a positive fact the settlement of disputes system of the World Trade Organization, which imposes sanctions in unilateral cases involving stronger countries and weaker countries. This was a practice that was used to maintain the rights of intellectual property furthermore. Finally, as a very relevant contribution, we mentioned the Agenda for Development of WIPO, whose main objective is, we're talking about post-treaties, this is 21st century, trying to exploit what we call the flexibilities of TRIPS for developing those less favored nations. We have those who point out that the substantial system of intellectual property includes ethics for development. There are others that point out that it is against the ethics for development. In this case, They say, as a first argument against independence, that the dignity of the less favored nations that were the powers, that it was the powers who imposed and conceived the system in exchange for what? In exchange for something that was basic for the survival of the less favored nations, the possibility to develop the raw materials. If the less favored nations were not part of the system, of the world trade system, they would not be able to place the goods in acceptable conditions. They would not be able to trade their goods in developed countries. Therefore, some interpret this as a lack of freedom to adopt TRIPS. They were coerced to act in order to sell their raw material in developed countries. They also mention discrimination, because the standards of protection of intellectual property rose sharply in less advanced nations. It went up to levels that were not achieved in those countries that later on became developed countries. It's something similar to what we say today about the environment. Many developed countries look after the environment right after they themselves exploited and devastated the environment to extract goods that are essential for them and that were taken from Latin America or Africa. It is said that they had no scheme for intellectual property when they developed, and that is why knowledge could flow more easily in such a way that it led to development. As a good example, they give the case of patents on pharmaceutical products, which was recognized at a world level, I would say, after the second half of the 20th century. Let us remember that in Switzerland, a country which is a symbol for pharmaceutical industries, there was no protection for patents of pharmaceutical products up until the 20th century. Now, regarding fairness or justice, the threats that would finish with the TRIPS system, it is pointed out that we still have threats, in fact, and also threats for those who used this TRIPS flexibility in excess. For example, the watching list of USPR, another additional example, the embargo of assets from one country to another due to the Doha Agreement. They come in transit. These goods include medical products, but an embargo is imposed on them by developed countries as they travel from one country to another. Regarding the agenda of WIPO, that all citizens in developed and developing countries recognize as very positive, it is pointed out that it exists thanks to a claim by undeveloped countries, and that it is a necessary help, but that it is accessory, and it has not been able to change the substantial system of intellectual property. So in view of these two visions, what do we do? Evidently, there is a contradiction between them. So how can we come out of this contradiction, taking into account the objective of the ethics for development, which is the advance of mankind, of nations, and that part of the world which is not privileged? So we need to think that ethics points as its main duty to look after itself, and that the virtue of ethics is to be prudent, to know how to act whenever possible. And in this case, several solutions have emerged. In fact, this means to increase the technological heritage, the cultural heritage through alternative means in this alternative to the traditional intellectual property scheme, like fiscal stimulus, coordination with private investment, the enhancement of public domain knowledge systems, which in which case WIPO has contributed tremendously. It is also convenient to use traditional elements strategically, like open code programs, to use more intensively and with more imagination all laws of free competence defense, to create a culture of innovation that is beyond our countries. And this is very important because ethics should always try to maintain hope alive, a rational kind of hope in terms of potential development, saying it is possible to have technological development so as not to stay behind, given this divide that may stay as it is or expand, such as the case of the wealth gap. And in the end, to obtain, by means of the right policies or coordinated policies that are appropriate for the less developed countries, to obtain an acknowledgement of the principles in the system. So they go beyond a simple declaration of principles and becomes something that is like an obligation mandated to the less developed countries or underdeveloped countries. And that this should go well beyond the issue of health, that already made some progress after the Doha Declaration. And it should be stated, as the principal statement in TRIPS says, food, education, and all aspects that are considered basic for development, so that the transfer of technology becomes a reality, so that the transfer of investments from developed to less developed countries, and not the other way around, which is unfortunately the case. So the less favored nations are now paying for this exhaustion of the terms of exchange, or when they buy technology or goods from countries in the north. Now, the final question, my final question, in this ethical dilemma, can a SIP be neutral? I don't think so. Definitely no. ASIPI must take steps within the institution, and especially at the level of the ethics committee, to study this problem in depth. As ethics committee, we have already dealt with this professional ethical issue, but the question goes beyond this. It has to do with what is of interest to us. It has to do with the transference of knowledge, the technological growth of our countries, which will translate in higher well-being of people who are part of our countries. And this can only be achieved, as an ethics philosopher from Spain would say, Adela Cortina. She said, this can only be achieved through a globalized ethics. In one conference that was held in Costa Rica, at the International Association of Ethics for Development, she said that the problem the world faces today is that trade has become global, economy has become global, but ethics have not become global. And in a world with uncertain ethics, the strongest will always be the victor, or those who have more political or economic clout. So it is essential for us to develop a globalized ethics. It is urgent to place this globalized ethics at the level of nations so that it flows to international organizations. And second, this was pointed out by an economist, and this is very important. He's a Nobel Prize winner in Joseph Stiglitz, advisor to President Clinton. The issue of technological development and the importance of intellectual property in human progress must be conceived in a multidisciplinary way, and with philosophers, with anthropologists, sociologists who study humanities, lawyers, experts in intellectual property. But it needs to be global, not just in terms of its geographical universality, but also in terms of the universality of people and disciplines that get together to study this project of global ethics that is urgent.
As you can see, the challenge that this implies for ASIPI, which is an association made up in its majority by members who come from underdeveloped countries, and an association where we have members from other countries that do not come to see here what other organizations do, but rather how intellectual property is developed and what are the concepts of intellectual property and technological development. And for the third world, this is an unavoidable challenge. It is not about taking sides. This is about becoming a meeting point where the different disciplines are brought together, where the different associations come together and the different views in order to start to conceive this globalized ethics, which is so necessary in this world. Thank you. Thank you, Sergio, for your excellent participation. Definitely, it is very clear that ethics is a discipline, is a topic that always gives rise to discussions. This is an inexhaustible topic, but after your presentation, we now face the challenge as professionals and as human beings, of course, and as members of the association of ACIPI, which is an association that deals with intellectual property. And as you mentioned, intellectual property protects new knowledge, which is a key for development. And the challenge we face is to continue discussing these subjects. We should always take these into account in order to always have a stance. And of course, I highlight what you mentioned in the sense that we have the responsibility of striking the balance between the loyalty to our customers as well as to human beings and society. That is quite clear. Thank you very much. I will now give the floor to the next speaker, Dr. Marco Matías Aleman, who is joining us from Switzerland. He is a lawyer from the University of Bogota and specialized in corporate law. He has a master's degree of Alcalá de Henares University in Madrid and also has a PhD. He works at WIPO since 1999 and has also researched at the Max Planck Institute in Germany. He held a position of director of the Colombian Office of Industrial Property. He also was practiced as a private lawyer in Colombia and has written several papers on the topic of intellectual property. I'd like to congratulate him on his recent appointment as Deputy Director General of the Ecosystems of Innovation at WIPO. Welcome. Thank you, Monserrat, for your kind introduction. Thank you very much to ACIPE and the authorities for the kind invitation to make a presentation in this very interesting panel. I would also like to thank my co-panelist, Mr. Sergio Amenábar, who made my life easier after his brilliant presentation on different ethical dilemmas, and particularly in the framework of ethics for development. So I will make a brief introduction, and then I would like to participate in a discussion which I think might be interesting. So what we're going to refer to now are some considerations on ethics, and particularly the context of ethics for development, as well as the topics of intellectual property. Allow me to start with a general introduction to the topic. At present, when intellectual property is at the center of discussions, is at the center of the considerations, is at the center of the different designs of policies, because this is an economy of knowledge, it is that reason why we can say that issues related to intellectual property are not always in the forefront. But we think that it is the time of intellectual property to shine as never before. Intellectual property is now at the very center of the economy for development. But the paradox is that never before were intellectual property issues faced with so many challenges. Never before have these issues faced so many arguments, which to a certain extent provide a tension with these traditional concepts of intellectual property. All consumers in the search for copyright, for example, copyright is facing enormous challenges, and the theory of intellectual property is based on the way the exclusiveness is protected. If we jeopardize that protection, then the system fails. Or also researchers and libraries which seek in different ways to have access to the result of investigation and to all this scientific material with total freedom. It is quite understandable that the investigators wish to access these, but also authors wish to have their work to view their work as a livelihood. Otherwise, they would have to dedicate themselves to other things. The issue of open source and how the open source current as a way to access information and all the opposition of to the patent system as a way of appropriating knowledge. So for many of them, knowledge is a public asset. Under the public asset, this should not be subject to protection. There are also discussions on patents and health.
Negociación.
There is a negotiation between the exclusiveness of the holder as part of the innovation policy and the interest of society of having access to medications, or also discussions around the patentability of raw materials as a basis for the entire biotechnological industry, which has contributed to so many things in our society through different types of developments. For example, microorganisms produce an effect, or in the industrial production of certain products, such as pharmaceutical goods. So society is enormously benefited from these developments, but on the other hand, there are tensions between those who consider that certain forms of life, such as plants and microorganisms, should be outside the protection, or also the discussion around traditional concepts that lead to a tension, a strain between those who wish to take advantage of technical knowledge, which is in the hand of some communities, and exploit this in a traditional manner. But without doubt, it might be that this would provide the basis for new industrial developments and then become pharmaceutical products or some other kind of products, such as cosmetics or other products of that nature. At the same time, there is the interest of these communities being the ones to determine whether they authorize this and under which conditions this exploitation takes place. Therefore, I think it is quite easy to conclude, in the sense that there is an ethical reasoning that justifies intellectual property, but it is also easy that there are challenges that are also valid. So we have to figure out solutions that allow those of us who are interested or are passionate for intellectual property to have the necessary tools to defend this based on solid arguments. Thomas of Aquinas was already said that the positive rights can be viewed or defended or understood only when these are fair and legitimate, and they're only fair and legitimate when they produce general good or benefit for the society. So the intellectual property rights are private rights, and that argument is often enough to protect this. But many think that private rights protect an ultimate goal, and that is a goal of the society as general. So in other words, these discussions arising in the framework of ethics, and particularly in ethics for development, are welcome discussions, not for the purpose of eroding the foundations of the system, but rather to strengthen it so that it can be clear how the intellectual property system responds to ethical and moral reasonings that are at the basis of the system and at the basis of many of the practical discussions or even more philosophical discussions of the intellectual property system. Now, let us look at some of these topics. For example, we can quote some that are inherent to a patent law, such as defining the patentable matter, some exceptions or limitations. We could also see topics related to certain behaviors of the holders of intellectual property rights and the potential abuse of holders vis-a-vis these rights. We can also analyze the behavior of potential actors who are not holders, for example, unfair competition. We could also look at certain topics such as a conflict arising between different types of rights, for example, fundamental rights. And we could also focus on those conflicts arising from tensions between different policies, such as policies of innovation and health. I will develop some of these topics in order to see which are some of these strains and which are the different standpoints. When we analyze the issue of patentability discussions, which I think is one of the most important chapters of the patent law, here authorities decide on one hand if they wish to use a patent system to promote innovation, in other words, issuing patents, or if they wish to use a patent system to promote access, in other words, not allowing patents in certain fields where they wish to privilege access. And there's an enormous ethical dilemma here where to place the stress, particularly on an issue of development. Should we focus on being an innovative society and the patentability field should then be open so that inventors can have patents and then through their invention they create well-being and wealth for the society? If that is the case, then patents have to be made available because we don't stimulate innovation denying patents, or we cannot promote invention excluding issues that can be patented. Now, in some cases, wish to favor access, and to favor access, there are several options. The first one is not to issue patents, then you favor access. Now, what interests us most as a society? Many rulings have stated that if we focus on static efficiency, then we are solving today's problem because we don't access these patents. But if we focus on dynamic efficiency, namely the problems we're not aware of yet, the problems that will arrive in the future, if we wish to find a solution to this, we have to generate a current of innovation that only works if the system of intellectual property, and in this case the patent system, really contributes to promoting new ideas. But we see that in these chapters of patents, there are some that regulate topics that are at the border of ethical and moral considerations in a more or less direct way. For example, excluding diagnostic and surgical methods for treating people or animals has evolved in recent years. For many years, it was considered that protection of therapeutical and diagnostic methods were not done because the requirement of industrial investigation was missing. Now, industrial application was an issue, and these were excluded because of a consideration that is fundamentally of an ethical nature. In other words, it is wished that the doctor, the physician, can use the diagnostic means or the therapeutic or surgical means that is most convenient for the interest of the patient. With that aim, the largest amount of freedom is provided for being able to choose. And this would place that doctor, that physician, in a quandary. Those are ethical issues, but then standards make it clear that this is not applicable to pharmaceutical products who wish to be free from patents to stimulate innovation. This is not applied to the diagnostic kits or the medical devices because we wish to promote innovation. And what is understood by these methods of diagnosis, therapeutical and surgical options, in some cases there are developments that do not fall in under this exclusion. The second example is that in most of the legislations, some exclusions are made to protect morale or public order. Some inventions are against public order or morale. We understand these as those whose exploitation leads to one that goes against these values that the society wishes to protect. For example, exclusions related to life matter. If we look at the European regulation, a balance is sought to be achieved in the sense that an animal cannot be subject to a patent because of the suffering that scientific research might imply. But if as a result of that a technological or scientific result is obtained to benefit humanity, then that benefit is above the suffering of the animal, and at that moment the ethical consideration is in favor of the patent. So a balance as such is expressed directly in a patent law, such as the biotechnological regulation. And a good example of exclusions to patentability considers some issues related to moral or ethical issues. And we also have exceptions and limitations. We have the rights of the holder, and here I would like to call your attention to some exceptions. Exceptions to this right are to favor a public policy.
Otherwise, there's no need to have an exception, because the holder has his rights limited. We withdraw something from him that is useless. On the other hand, if you remove something to limit that right, it's because you perceive a public policy. So some of the exceptions, if they go alongside a policy, have a positive impact on society. For example, there are some limitations and exceptions in the case of compulsory licenses when we are in case of abuse on the part of the holder or acts that are against free competition. So in those cases, the behavior of the holder of the patent receives a sanction. Or in the case of licenses, compulsory licenses or non-voluntary licenses, when they are granted due to an interest of the society as a whole, like public interest. And in that case, we say that when there is public interest for the society and an individual exclusive right, which one is more important? Different German tribunals have ruled recently by interpreting this concept of public interest. When I read these interpretations, it's clear to me that there are elements we need to take into account. For example, public interest does not mean that a product has a cost and it has an impact on the budget of health entities. We all know that patents are there to allow the holder to get a plus, and that plus will stimulate the holder to continue investigating, innovating. The problem is when that plus is excessive, is not justified, and this is where public interest considerations become important. In one of the rulings, the tribunal said what we expect effect by this compulsory license is not feasible because there are other equivalent products at a better price in the market. So the society is not affected if we remove this particular medical good. So there are different elements to be considered in that public interest equation. It is not true that public interest always implies not knowing the rights of the holder of patent, because that right is a property right, and secondly, because it responds to a public interest policy such as the innovation policies. If you're interested in going over these recent cases in the German law, it's a Telegrabir, and the ruling was in July 11, 2017, and the key element was public interest. Or the case or the exception based on previous use. Why whoever uses an invention in secret gets a defense. Why do we defense? Defense here is limiting the patent holder in case of someone who's been using it before or continued using it. We wanted, because we consider that in the first to file system, which is used worldwide, even Latin America, we consider it would be unfair if someone, for different reasons, economic reasons, or because not knowing or because of a choice, decided to exploit it in a confidential way, seeking the protection of industrial secret, and decides to do that. If someone does it honestly, were it illegitimate, the situation would be different. So someone attains the same development and requests the patent. We deem it fair that whoever filed for the patent obtains a patent right, exclusive right, that provides the opportunity of a protection vis-à-vis the others, with an exception vis-à-vis the previous user. It would be extremely unfair for the prior user not to continue using this invention under certain conditions. So the same prior user figure demands the prior user to have used the invention in a confidential manner, but also he must have done so in good faith. So they introduce a concept which is very common, very usual in different legal systems, including the patent system, and I'm referring to the good faith concept. What do you understand by good faith in the case of this exception? And these are some answers. The Netherlands said the applicant has a right to continue using and acting with the exception of the case whereby his knowledge was obtained. No, I should reword it. He can continue using the actions enshrined in the patent law that would otherwise be considered an offense, but are not, because the user did it before in good faith at the time of the application for a patent. Or in the case of the US, which says when the prior user acting in good faith uses the object commercially or uses the object of the patent commercially, he will have a right of not being sued. He will have a right to defend himself if he's doing it in good faith. Undoubtedly, there are many references to good faith when we deal with the exception of the prior use in patents. These are two topics where ethical elements inspire the legislator or whoever makes a decision in the case. We also said that on many occasions, this has to do with the behavior of the holder of patent. In recent times, during the pandemic, we've seen different behaviors of holders of intellectual property who, having the right, considered elements based on moral or ethical issues. An American company in the pharmaceutical field gave up their rights on the brand Caleta in Israel because they considered that the requests from civil society were legitimate. Or after a mass media campaign, Labrador Diagnostics in the US decided to suspend an action on an offense against a startup they were investigating in terms of the kits to diagnose COVID-19. They had a right to continue, but they considered ethical or moral issues push them to reconsider. Or some holders that started voluntary actions in this case. They are not obliged to do that, but they think it is correct. A pharmaceutical company, Gillian's, on the one hand, renounced the orphan globe status of one of their products. Remdesivir in the US, they had a right, but they considered that given the circumstances, it was not the best time for that kind of action. Or included in a list of 127 countries worldwide, included licenses, voluntary licenses under special conditions in order to produce and facilitate access to remdesivir in those markets of those 127 countries. And there are many other examples. This is just one case of voluntary conduct on the part of companies. Now we have the case of holders and their conducts that oppose unfair competition. If you've read the Paris Convention, in one of the articles, we set forth the different elements of unfair competition. And it says here that any act of competence that is contrary to honest practice in industrial or commercial matter are unfair acts of competition. This is a very generic kind of description. It's a competition act that goes against industrial or commercial practices. And contrary to what people may think, that this standard only limits to what is enshrined in number 3, the use of marks and brands and trademarks, the regulation says the following in particular will be prohibited. In particular, it says. So it is a list that countries can go beyond. So this element of unfairness in the commercial practice will be sanctioned in the Paris Convention and all its regulations. And finally, Article 39, as we all know in the TRIPS, expanded this to cover industrial secrecy, commercial secrecy, confidential information, whatever name you like to give it. So one example from an unfair trade practice is illegitimate access to this type of information that is considered a secret. And then in the footnote, when it talks about secrets and protection mechanisms, it says, a way that is contrary to commercial practices that are honest means at least breaking a contract, breaking trust, or leading to canceling the contract or trust, and it includes the acquisition of non-disseminated information by third parties that know or should know of the existence of this secret. So there is a list of practices considered unfair. And in light of Article 39 of the TRIPS, we are clear that these practices want to be avoided. These are ethical reasons more than moral reasons. We consider them unfair. And as I don't have much time, I will move on to the next part.
Now, to conclude, I'd like to give two examples. One is the example of when we enter into a conflict of two types of law, as is the case of the fundamental right that every individual has to the material and moral interest on their works. This is protected in Article 27 of the Universal Convention of Human Rights, and this consists, contrary to what people believe, in that right, this right. It's not that the copyrights and are fundamental rights, but the fundamental right is the right of every citizen in his or her jurisdiction, that legal systems are in place which contribute to the protection of that individual's material and moral interests. The copyright of an author over the work or the invention, and this property right is also a fundamental right in many jurisdictions. But the fundamental right we're referring to here, Article 27, is a fundamental right to count on an appropriate legal framework. On the other hand, we also have the right to participate in the cultural life and to benefit from the scientific progress of society. So how can I benefit from scientific progress when on the path of the patent system, scientific development is promoted, but the result only leads to the benefit of only few people who can pay for this? But the right to benefit from scientific progress is also a fundamental right. And that is where these two fundamental rights, the fundamental right to having access to one type of technology or to one type of product specifically, might clash against the right of the holder to protect his or her invention or work. And these two have to come to terms on different ways. There are innumerable cases in Europe, for example, where fundamental rights, such as a right to free expression, has had to strike a balance with the holder of a given work. And there have been rulings both in terms of copyright and also in terms of certain brands, where the person who has done the infringement, there's two rights in conflict: freedom of expression and the right of industrial property. And very often the courts have ruled in favor of the holder. So it is not that whenever we say that there is a human right in opposition to intellectual property, these things have to be put and considered in order to make an adequate ruling. And then we have the intellectual property system as a mechanism to promote innovation, this as a way to promote scientific development, and we have copyright as a way to promote cultural development. So these specific rights can enter into conflict with the particular rights of another type of policies, such as health policies that favor access. And I think that when we were told that one, based on intellectual property law, disregard the rights of health policies and the fundamental right to the patient's access to health, I think we are comparing pears with apples, because the fundamental right of the patient's health is something that we cannot question at all. And we have to figure out a necessary solution so that our society, if technological solutions are available to assist a patient, that we can preserve that life and respond to the needs of that patient. Now, it is difficult to consider that the burden of the right to health is then transferred to the industry as if this were the only way to find a solution to this conundrum. There are many stakeholders, there are many public policies that have to be taken into account so that in order to respond to the right and interest of innovation and the right to have access to health, to really find a middle point. So, Monserrat, I give the floor back to you. Thank you. Thank you, Marco, for such an excellent presentation. This shows how clearly we see examples of cases in which there are ethical considerations in place. And in the case, for example, of certain situations where the public interest of society and the particular interest lead to favoring maximizing the benefit of the majority of people. And this also regarding many of the examples that have been mentioned. We have only very little time left before we finish this panel, but I would like to congratulate you on behalf of Martín Torres Cardoso, particularly to Marco Matías, and to the Professor of Intellectual Property Rights from Colombia. So we have 6 minutes to see if there are any questions. Sergio, how do you think that you could implement and apply universal globalized ethics? Is there an essential condition for this? I think that this is possible. Ethical rationality should feed political rationality. Therefore, if ethics tends to benefit humankind, like Aristotle said, to the joy of humankind, then politics seeks to precisely exactly the same result. Policies when well implemented and policies that are focused on the common benefit is not in contradiction with global ethics and global policy. Now, the problem is, as I mentioned earlier, and this is a result of an observation, that although global policies were created, policies of global interest have been created, these are ultimately the policies of certain stakeholders. There is no previous vision that feeds a global type of ethics, in the sense that any political decision on the topics we have at hand or any others, these have to be made based on the common good. Therefore, that conditions will happen. It is a moral strength to have ethics as a reason for the policy and not vice versa. And as I said, the end should not be a means, and these should not be opposed to means as an end. I think we still have a long road ahead to achieve that, but we also have I believe in hope. I think that we as human beings manage to overcome things despite stumbling along the way. But the time will come in which humankind reflects on this, that policies reflect on this for the benefit of common good. And if politics and ethics do not interfere, but rather one and the other should be focused on the same good, then we have a globalized type of ethics, which will then lead to a global policy and not to a policy that could be interpreted as the outcome of the law of the one who is stronger. A question for Marcos. The Intellectual Property Office, which is the role in order to manage antagonic interests, for example, the conflict on certain rights or policies? Well, there are several elements, and there are some in which the office can discuss these and deal with these, but others go beyond the role of this office. In some cases, the office has received cases of a mandatory license and to identify whether there is abuse of the holder, of an inadequate exploitation or of an excessive price, for example. On some occasions, I see that the office is in a bad position in order to identify whether a price is excessive or abusive or not. Because I think that there might be other authorities, such as the authorities on competition, who have a better capacity to identify whether this is a case of abuse or not. In other cases, they might be in a better position, for example, to qualify an application for a patent if an invention goes against the principle of morale and public order. It might happen that in some cases that would be the case, but in other cases not. And I will give you an example. If, for example, an application would be made for a photocopying machine of very high quality that can be used to reproduce artwork in a museum for the purpose of preservation of these artworks. This is a wonderful invention, and according to the patentability principles, these could be accepted, but someone can use it to forge money notes, or this could also be used for a different type of purpose, and then that patent would be denied. In that case, the office can clearly establish that they cannot judge the potential undesired use of the invention because it also has an honest application. But an invention that refers to a substance to be used as a biological weapon can have no other purpose than that. And so in that case, the office can really determine its non-patentability. In other cases, with live matter, some rulings have questioned the European Patent Office on whether something should be considered morally patentable. In some occasions, the European Union has stated that that ruling goes beyond the capacity of this office, and also some other entities such as Ethics Committee, which can enter into this discussion. So thank you very much to the two of you. We have run out of time. Thank you very much. This is an exhaustible topic, and we could continue going on and on speaking about this topic. We can continue discussing this at other ADPIC meetings. Enjoy your day. Thank you very much.